Mr. Martin, good morning.
Good morning, Your Honor. Mr. Chief Justice, and may it please the Court, Kevin Martin on behalf of Bank of America in its capacity as fiduciary for the tax-paying trusts, and with me today I have Joshua Daniels. Your Honors, the Massachusetts fiduciary income tax applies to a trust only if one or more of the trustees is an inhabitant of Massachusetts.
Can I stop you? The fiduciary income tax is on the trust's income or on income paid to the fiduciary?
It's on the trust income. My understanding is the fiduciary receives that income, and then it functionally pays the tax.
But it's the trust that's paying the tax.
It's the trust that's paying the tax.
In fact, in the statute, there's a specific exception for what the trust pays to the fiduciary for its work. Right?
That may be the case, Your Honor. I'm honestly not sure. But this is the trust income which is being taxed. The abatement was sought by the trusts, who are the actual 34 appellants in this case.
I guess my question is even a simpler question than that. So if the trust collects the money and pays it all out to the beneficiaries, is it a double tax? Does the beneficiary have to pay tax on that as income as well as the trust paying tax?
Again, Your Honor, I'm actually not sure of the answer to that question. I would
I
assume
think the
that if the
answer is no.
beneficiary...
I mean, it's either imposed at the beneficiary level or at the trust level, isn't that right?
I think that's right.
That makes sense to me, Your Honor. It would make sense not to have a double tax on the income.
Yeah, I was just wondering if this is a corporate dividend tax.
Right, this is not Bank of America's money. We're talking about the money for the 34 families or whoever is receiving the money from these particular trusts in this case.
So if you prevail, does the beneficiary end up paying the same tax anyway?
It would probably depend, Your Honor, on where. So, for example, Bank of America is in North Carolina. U.S. Trust is in New York. It's possible, although I'm not sure that's the case, that tax could be imposed there, and ultimately the beneficiaries will receive a distribution. But if the beneficiaries don't pay tax, if the trust doesn't, then the beneficiaries may benefit from that rule.
How does it work in this case, though? Because as I understand it, the tax that's here is for the unascertained and unborn beneficiaries. Because I thought, from what I read in the record, that that's the only beneficiaries, or those are the only potential beneficiaries who are treated as being inhabitants of the Commonwealth.
That's correct, Your Honor. In this case, we don't even know if there are any beneficiaries.
Well, I'm just interested. Let's just say that as in terms of how this works, who pays that, assuming that the tax needs to be paid, who pays it?
The trust pays the tax, Your Honor. And so the bank, in its capacity as the trustee for these trusts, would remit the money to the Commonwealth on behalf of the trust.
And it would be taken out of whatever portion it is for the unascertained and unborn.
Correct. So for example, I know for some of these trusts, they received capital gains in the tax year in question, 2007. The capital gains come in, the tax goes from the trust to the Commonwealth. That money does not appear as money which is available for distribution to the beneficiaries whenever there may be either a mandatory or a discretionary distribution to the beneficiaries. I mean, one of the issues here, for example, is that money may not have actually gone to any beneficiaries in 2007. It may have it remained with the trust because the trust either did not have a mandatory requirement to pay out and was not asked to make a discretionary distribution.
So, Chapter 62, Section 1F and Chapter 62, Section 14, or their predecessors, appear to have been on the books for about 100 years. Are we looking at a fundamental change in the way the Commissioner has been taxing corporate trustees, or is this case just come up for the first time in 100 years?
We would say you are looking at a fundamental change, Your Honor.
Well, how was it interpreted previous to this?
So for the first 40 years of the statute, there was no statutory definition of inhabitant, and so the common law definition of inhabitant was applied to corporations and to individuals, and those despite the presence of Section 14, and those were very different definitions. For a corporation, it was the state of incorporation under the common law test, and for an individual, it was where that person had established their domicile and whether they had ever decided to change their domicile. So Section 14 from the get-go never meant apply the same standard of inhabitancy to both corporate and individual trustees. All it really meant was apply, as best we can tell, apply the 3 criteria in Section 10.
But after Section 1 was enacted, which came first, right, as to domicile.
So Section 1F1 is adopted, Your Honor.
And when is that?
That's 1955.
And that's adopted, and so that test gets applied differently to, because domicile means something different for corporations than it does for a natural person.
See, we don't understand that to have changed anything at all. 1955.
You're saying that just follows the common law.
It simply followed the common law, and our understanding is that that was simply adopted in 55 because the fundamental basis of the income tax structure for individuals changed that year. And so 1F1 comes in and it simply says resident, which is now the basis for individual income taxation, and inhabitant mean the same thing, which is domicile. And on its face, it says any natural person. There's no evidence that in 1955, the legislature thought that it was adopting a new definition which would as well apply to corporations.
But it has applied to corporations.
So
Well,
1990,
I don't think it has, Your Honor, because, again, the common law, it happened to have been the same standard, which is domicile. It's called the same thing. But from 1916 through 1955 and even today, domicile means something, it's a different standard for corporations and people.
So
So 1995 comes the amendment we're talking about.
So 1995 comes the amendment we're talking about. And again, that refers to any natural person. And the purpose of that amendment in 1995 seems to have been something particular to natural people.
Now, is there legislative history?
There's not legislative history in the
On
sense
its
of a
face, it looks
committee
like a
report.
snowbird, kind of.
It's a snowbird issue, Your Honor. I mean, my suspicion is that in the early 1990s, airplane travel becomes easier. You have more people spending half the year in Florida than you did before. And so the legislature decides to deal with that issue by adopting a new definition for any natural person, which focuses not only on where they have a home, but also where they spend most of their time. And if you look at the commissioner's interpretive guidance, which came out the following year, it's directly addressed to that issue of snowbirds and where people are spending their time when they have more than one home. If there had been an intent in the legislature and an understanding at the department that this was a fundamental change not only for individuals, but also for corporations, then you would have expected somebody to have said something about it and to provided some guidance, but there was silence. The reason why this, sorry, go ahead, Justice Botsford.
No, you
I was going to say, I think the reason why this came up in the mid-2000s for the first time was that there were some mergers, and as a result of the mergers, you now had out-of-state national banks dealing with some of these trusts, and so people realized there was a
Yeah, but let's
a
get
issue.
back to F1. I mean, because it seems to me that domicile has been applied to both natural persons and corporations.
It was applied to both, Your Honor, but not as a result of F1.
Doesn't matter. I mean, it's F1 is in existence, so why can you say it's not as a result of F1? I mean,
It matters
isn't-
for
is it, are you saying that the Commissioner of Revenue does not apply F1 to corporations?
The commissioner does not apply F1 to corporations. Domicile was the test for corporations.
But it is the test.
Beginning in 1916, when,
The test under F1.
not because of F1, it's the test because in 1916, when sections 10 and 14 were adopted, it was already domicile for corporations, which meant state of incorporation. The fact that domicile also was adopted as the definition for individuals 40 years later did not retroactively suddenly create the basis for why it was domicile for corporations. It had been that all
So
along.
you're saying you can't read F1 to apply to corporations?
Correct. The reason why trusts administered by corporate trustees are taxed is not because of F1. It's because it was already understood in 1916 under Section 10 that they would be taxed if the corporate trustee was domiciled, was
And what's the
incorporated
purpose of 14?
here. The purpose of 14, which in 1916 was adopted in the very same statutory provision as Section 10, appears to be to say if the three criteria in Section 10 apply to a trust administered by a corporation, then that trust also will be taxed, just as a trust administered by an individual trustee would be taxed. Because again, there was no statutory definition when 14 was adopted.
Well, I guess that goes back to the question, if that's the case then, and now you've got F1 and F2 added, I guess I just don't see why you wouldn't now interpret it the way the commissioner is.
Well, two reasons, Your Honor. First, on its face, Section 1F and 1F2 say any natural person, and so we think that the best reading of this, particularly taking into account the principle that any ambiguity in tax laws is read in favor of the taxpayer and in
Yes,
favor
but
of...
it says but 14 says corporate trustees are supposed to be treated as inhabitants, right?
It
As
does say that,
fiduci-
Your Honor, and our understanding is that that was adopted in 1916 when there was no statutory definition, and that just means look at the three criteria in Section 10.
But Section 14 wasn't changed. after the adoption of F1 or F2.
And we think that reads in our favor, Your Honor. Again, taking into account the principle of Extra and Oliver, that any ambiguity is read in our favor.
Where is the ambiguity? I'm having trouble seeing ambiguity. I mean, I look at that and I see completely straightforward language.
The ambiguity here, Your Honor, is that Section 1F1 and 1F2 on their face say any natural person, and there's no indication that the legislature intended those to now be applied to corporations, and that Section 14, when it was adopted in 1916, did not mean apply the same definition of inhabitant. It simply meant apply the three
But
criteria
you
in
have Section
10.
14 coexisting with F1 and F2.
Right, but it's not a
Why
ref-
wouldn't you read this in terms of the entire statutory scheme?
we are reading it in terms of the
No,
entire
because you don't want
statutory
Section
scheme.
14 to apply to F1 or F2.
Because Section 14 is not a reference to the definition of inhabitant, because if it was, then way back in 1916, you'd be trying to find some way to apply the same definition of inhabitant to both corporations and people, which has never been the case. And even if you were to apply, I mean, not even the commissioner believes that you can actually apply the same definition.
I
to
take
both.
it the commissioner's position isn't that F1 applies here, is it?
It's F2.
Well, well, it has to be both, because the commissioner's view must be that in fact, this is the gist of their red brief, that 1F1 applied to corporations, and therefore the legislature intended 1F2 to apply to
And
corporations
why
as well.
couldn't 1F1 apply to corporations? Because the word domicile can be applied to both individuals and to corporations.
It could, but that would be sort of like saying the space shuttle and a stagecoach are both methods of transportation. They're very different tests. For a corporation, it's the state of incorporation. For an individual, has that person lived in this place
Well, but that could
before?
also go the commissioner's way. You know, you take the same word domicile, and it means something, it has to mean something different for the corporation, and it has always been applied as state of incorporation, and it means something different for that than a natural person, but you have to take the same term and apply it to both in order to be able to effectuate Section 14.
Well, again, Your Honor, we would disagree with that, and I would say it's at least ambiguous whether that's the way to read it, and therefore under Extra and Oliver.
Keep saying ambiguous, and I don't see where the ambiguity, I don't see where the ambiguity lies.
The ambiguity comes in, Your Honor, because when Section 14 was adopted in 1916, we know it did not mean apply exactly the same test, which is the commissioner's position and what the board ruled, that it somehow means apply the same definition of inhabitant. They happen to have the same name, domicile, but they're very different standards. So Section 14 has never meant to apply.
Is there any ambiguity created by a conflict between Section 10 and Section 1F?
We don't see a conflict, Your Honor. We simply don't see how Section 1F applies to corporations at all, at least how it's clear that it applies, notwithstanding Section 14. And again, so therefore the ambiguity should be read in favor of the tax-paying trusts.
So you would say Section 10 is really the controlling section here because it's the concept of domicile.
It's that Section 14, when it was adopted, applied to Section 10. Section 10 did not have a statutory definition of domicile. It had a three-factor test, and there were different standards applied to corporations and to individuals as to what inhabitant meant. So it's just been different from the get-go.
So you started out by saying there are a couple of things that need to apply before a tax would apply. Number one is the trustee has to be, well, under F2, let's say. It's got to be here. I mean, national banks are everywhere, but so got to be here. What's the other that?
So the three criteria under Section 10, Your Honor, the settlor must have had some connection to Massachusetts at one of three defined dates. The beneficiary must either be a Massachusetts inhabitant or be unascertained or unborn. And either the corporation or the individual trustee must be an inhabitant. Section 10 on its face does not.
So those three things have to be satisfied.
Those three things must be satisfied, Your Honor. There's no dispute in this case that the first two are satisfied. We're really focusing on.
And so how do you satisfy inhabitant if you're a corporate trustee?
So if you're a corporate trustee, Your Honor, you satisfy inhabitant for at least the first 80 years. There's no dispute about
but
this.
under the statute as it exists today, how do you satisfy inhabitant? You can't pretend the statute doesn't exist.
Sure. So we would say that it's exactly what it has been, which is that you are incorporated here. Now, some courts have looked at, and we point this out in our reply brief, some other courts have looked at the words place of abode, which appears in 1F2, and have said for a corporation, place of abode means it's either the state of incorporation, so the same thing as domicile, or it means the principal place of business. And there's no dispute, which for a national bank would be its main office. There's no dispute that Bank of America and U.S. Trust were not incorporated in Massachusetts, did not have their main office in Massachusetts, and therefore, even if you were to find that Section 1F2 applies to corporations, again, invoking the rule of Extra and Oliver, you should find a narrower reading of that than the presence and activities test.
In this case, this particular case, if I understand it correctly, when these trusts were set up, which was long ago, the corporate trustees were all Massachusetts banks, correct?
That is correct, Your Honor.
And just because these behemoth banks have done this, now you say we don't have to pay any taxes, right?
Your Honor, if an individual moves his home outside of Massachusetts but continues working in Massachusetts at an office, that person would no longer be either domiciled or have a place of abode in the state. So too with a corporation. If the corporation moves its place of abode, its home, outside of the state, even if it continues working in the state, then tax would not be due on these trusts. It's no different for an individual or a corporation under those circumstances. I see my time has expired.
Thank you, thank you.
Thank you, Your Honor.
Good morning, and may it please the Court. Assistant Attorney General Kirk Hansen on behalf of the Commissioner of Revenue. Let's just begin by reiterating, we're talking about what the three requirements are. This is about when a trust is deemed a resident trust of Massachusetts such that it's subject to the tax in Section 10. There are three requirements. The first being that the trust beneficiary has to be an inhabitant of Massachusetts unless they're unascertained. Second is the settler had to be an inhabitant of Massachusetts at one of the designated times in the statute. And third is that one of the corporate trustees must be an inhabitant of Massachusetts.
So if the beneficiary of this trust lived in New York, no tax.
No tax would apply, I believe, Your Honor.
But
If the beneficiary lived here, but the individual who set the trust up lived in New York,
At the time that was
Right.
designated in the statute. There are three separate requirements that all must be met. And in this case,
so if a
there's,
beneficiary is here in Massachusetts, and there's a distribution, they get taxed on that distribution, don't they?
well, I believe that the way that it is set up, that there's not a double taxation. That issue came up before, that if this tax may happen, if it's paid by the trustee, then the beneficiary isn't paying a tax again. It is set up to be careful about that. This case specifically, it's just addressing the one issue of whether or not Bank of America is as a corporate trustee, was an inhabitant of Massachusetts
But
for purposes of 10C.
the first two tests seem to apply only to natural persons.
About whether the resident.
Settler, beneficiary.
Well, I think it's important. Chapter 62 is a personal income tax code. So the word inhabitant is used throughout entirely. It's intended to be referring to natural persons, which is why the definition in Section 1F in general is about natural person. The corporate income tax is Chapter 63. But when the board looked at this case, they recognized Section 14 requires that corporate trustees be responsible for the tax under Section 10 in the same manner and under the same conditions as an individual inhabitant.
Section 14 came on board in
1916.
1916.
And so going back with the history of what the test was that was being discussed, I think if you look at the cases, specifically the ones that were cited on page 25, note 7 of the bank's brief, they cite two cases from 1893, 1926. Back then, the definition was inhabitant or inhabitancy equaled domicile. And it's because for corporations, we recognize domicile to be the place where they were incorporated. That was the standard applied, but it was always domicile. In 1955, Section 1F is originally adopted, and it limits the definition of any natural person, or it limits the definition of inhabitant to a natural person who is domiciled in Massachusetts.
So does that change anything?
Well, Your Honor, I would say that if you were reading all these statutes together, the legislature at that point had now defined the word inhabitant as it's used throughout all of Chapter 62 in general to mean a natural person who is domiciled in Massachusetts. But if context dictates that the definition has to be something else, and what we say, what the commissioner believed and what the board agreed with, I think is Section 14 does create this different context. It requires that the requirement of a trustee being an inhabitant of Massachusetts has to apply equally whether you are an individual, a natural person, or a corporation.
But the test for domicile is going to be different.
But the standard of then of being an inhabitant equal domicile applied to both. And yes, how you determine if a natural person is domiciled here is different than how you determined if a corporation is domiciled here. But the test in general of saying that inhabitant means a domiciliary of Massachusetts was the same test for both.
So when was F2 added?
That was added in 1995.
And that's what you are relying on?
Yes. And again, it goes back to the legislature, when they added it in 1995, changed the definition of inhabitant throughout all of 62, Chapter 62. But Section 14 still requires that corporate trustees be responsible for the tax under Section 10 in the same manner and under the same conditions. And the only way that that language can be given effect is if both prongs of the definition, both domicile and permanent place of abode, apply.
How do you give, under F2, any meaning when you're talking about a corporate trustee to the 183 days of the year, or whatever that is?
Well, banks may
Can't,
come.
really?
I think the answer then, Your Honor, is that if banks move into a state for more than half of the year, they are then having a permanent
But
place
there
of
isn't
abode.
that sort of sense of the snowbird where that can differ from year to year.
Certainly, Your Honor, that I believe is the main reason why they enacted 1F2 in 1995. But at the same
It
time,
wasn't intended really that in itself doesn't seem to have been intended to capture corporations.
no, and again, they wouldn't have changed the definition of inhabitant generally for corporations because Chapter 62 does not apply to corporations. It applies primarily, it's the personal income tax.
And the trust services don't need to be provided in Massachusetts under your definition.
No, they,
I don't,
No.
under the board's reasoning, I would say, if you look at what they said, it was they looked at the presence and activities of the corporation, the state, but what they then looked at and focused on was not just the general presence and activities of Bank of America, but the trust-specific activities that they had here in this state.
As to these trusts, but I mean, that doesn't have to be the case.
but wasn't the position, at least this is what the taxpayer argues, that in your reply, in some brief to the commissioner, excuse me, to the appellate tax board, I guess it was the reply brief of the commissioner to the appellate tax board, the position taken was that you had to look at the trust activities. Is that correct?
In the reply brief to the board, the commissioner did say that I think looking at the trust-related activities certainly is, that was a main focal point and certainly enough to say that here, Bank of America is a inhabitant where.
But that's not part of the test that the board articulated. The
That's-
trust act, that they actually, that whatever is in Massachusetts actually engages in trust-related activities.
Correct.
So are you really embracing the board's definition?
Well, sir, I think the board, what the board did was once they recognized that 1F2 does have to apply, then it had to determine how to interpret those words, and they looked at the words, giving them their natural meaning, natural ordinary course of meaning of what it means to be an abode or to abide.
But if you posit, because I think there is some evidence here that Bank of America does have some trust activities here, although not all of them that deal with this. But let's posit Bank of America, its entire fiduciary operations were in New York or somewhere, anyway, outside of Massachusetts. Would it be the same result here?
I don't know how how the board would actually come down on that issue because it's a different set of facts. They looked at the whole.
Yeah, but they articulated a test that's much broader than just this set of facts.
They articulated a general rule, but I don't think they were looking to find the final delimiting standard, or that would be the cutoff. And I certainly think there is one, but whether that has to be decided in this case, on these facts, I'm not sure, Your Honor.
So you would say the fact that whatever the board's test may be in another case, because there is evidence in this record of trust activities being performed in Massachusetts with respect to these trusts, that's enough.
Certainly for affirming the board's decision, yes, Your Honor.
Could we change the test?
Well, certainly there are several different rules that go into applying, and ultimately, Your Honors can decide whether the board properly decided this or could adopt a different rule if you believed so. But we think that when you look at all of the rules, what the board was trying to do, applying its expertise to interpreting the tax code, was looking for a general rule that seemed to give these words their proper meaning within common ordinary usage.
Have to have something to do with the trust activities, though.
Certainly, I think the trust activities, again, going with this case, makes it very clear that it's satisfied here, and if the court believes that that's the standard, I think you can go for a narrow, if you're going for a narrower rule.
But under your approach, I take it the trust activities could be satisfied by merely having a front office person who would greet potential trust investors.
Well, once again,
And none of the trust decisions were made in Massachusetts.
once again, Your Honor, I think the commissioner certainly wouldn't disagree that there are limiting standards, and that there may be a level at which it's not enough. That's not the case that was presented here. Where that line is drawn, I don't think we can say right now, but certainly on the facts of this case, the facts that were admitted by Bank of America, it's not just some activities. There were very serious, prevalent activities and presences relating to these trusts. They are listed on page 14 of the bank's opening brief. Pages 281 to 84 of the joint appendix was where they were stipulated to that they operated and staffed offices in Massachusetts to fulfill some of their obligations as trustees. They maintained relationships with beneficiaries of these trusts, administered the assets of the trusts, researched issues.
Well, there are no beneficiaries in these trusts. They're unascertained.
Well, at least for some of them. But, Your Honor, I'm noting exactly what was stipulated by the parties.
Okay.
And
Let me ask you, I was a little confused. It seems to me that the bank takes the position that the commissioner does not apply F1 to banks,
I think
corporations, but that somehow this is just it's always been understood that domicile and state of incorporation are the same thing, and to the extent that the test under 10 is met as far as inhabitants, it has nothing to do with F1.
I think, certainly I'm not aware if there's a decision before the appellate tax board that took that position. I think that's a misstatement of the commissioner's view. The commissioner's view would be simply that the any natural person language in the definition of 1F for inhabitant, portion cannot be applied when to determining if a trustee is an inhabitant for purposes of 10C. But other than that, I think the same definition has been applied to both. Before 1995, it was domicile, and domiciles applied differently to individuals versus corporations. And in 1995, both prongs still apply to corporations.
So you're saying that you would have prevailed even if there had been no 1F2?
No, if it was merely domicile, Your Honor, no one is disputing that Bank of America is not domiciled in
Okay,
Massachusetts.
so if the legislature had not amended 1F to add 1F2, you would not be here.
There was no argument made under 1F1. It is simply, if 1F2 does not apply, I think that it does.
Then 1F2, but I mean, the problem I've got with it is you have no legislative history to indicate or any reason to think that the legislature intended to do what you say that they did.
Well, certainly no one's saying that they intended to make this change per se, but there are standard rules that we have to take when interpreting statutes, one of which is that we presume that the legislature is aware of all of the different impacts it'll have. The word inhabitant shows up 7 times in Chapter 62, Section 10. Presumably, they intended the exact same meaning to apply to this word every single time it appears, including when it talks about trustees being inhabitants.
So when 1F1 was enacted, the legislature intended to include corporations because of the preexistence of Section 14, is your argument?
I believe so, Your Honor. And it comes down,
One for F1 and F2.
same rule.
Same argument.
Yes,
Same argument, it's just that on these facts, you need F2 to get to this
correct,
bank.
correct.
And is this the first time that the commissioner and the board have defined F2 to apply in circumstances like this?
I believe this is the very first time this issue has come up to be litigated before the board.
Okay.
And why is that? I mean,
So,
are they
unfortunately, I don't.
paying? I mean, are they being taxed and simply paying all these other entities who are incorporated elsewhere who are trustees?
Quite honestly, Your Honor, I don't know the exact reason why. It takes somebody paying the tax, challenging it in an abatement to have it come and continue to press it. I
Now, in
believe.
terms of going back to 1995, any legislative history? I mean, I'm trying to think back. That was Bay Bank, Bank of New England, Fleet were all during that, I mean, in that time period, there were a whole slew of Boston area banks which were being swallowed up. Was there any contemplation, anything in the legislative history that would suggest that it was concerned about that?
I don't I'm unaware of anything being within the legislative history saying that that was also part of the consideration here. But just going back to talking about the presumption, the word shows up many times throughout Section 10. If the legislature didn't intend for 1F1 and 1F2 to apply equally to corporate trustees and individual trustees, I think it was incumbent upon the legislature to amend either Section 10C or to amend Section 14 to articulate what the different standards were.
Let me ask you this. I think you've conceded in your brief that the incentives, to the extent there may be incentives, and I don't understand trust taxing at all, the incentives would be for Massachusetts residents or trusts that have Massachusetts beneficiaries to basically go to Arizona or someplace else and not use banks that have offices here.
Certainly, Your Honor, I think if we're talking about the constitutional arguments that were being raised and whether or not this discriminates against interstate commerce, that's where I believe that issue came up.
No, but I mean, you're conceding that so if a Massachusetts settler didn't want to have the Department of Revenue collecting tax on the trust, it would just go and make sure it had a bank as a trustee who didn't have offices here.
Yes, and I also would note, Your Honor, that I think no one briefed on this issue, but the taxing standards differ wildly among the various states. Some states tax based simply upon where the beneficiaries are inhabitant of that state,
Some where the investments are.
or where the investments are, where the settler was at the time it was created. Some rely on whether the trustee is an inhabitant or not. So regardless of where these trusts are, you have to look at all the states to determine if and where
I take it
taxes
there
are.
are set-offs to the extent that the trust is taxed in other jurisdictions.
Yes, Your Honor. Chapter 62, Section 6A does have a credit if taxes are paid anywhere else, and also in this case, the parties stipulated that no taxes were paid anywhere else, nor were any owed in any other state other than Massachusetts.
And just to be clear, wealthy settlor in Massachusetts establishes a trust in Massachusetts for her children who reside in Massachusetts. If it is not a Massachusetts-related trustee, the trust itself is not taxed, but when there are distributions to the Massachusetts beneficiaries, are those taxed as income?
I would believe, Your Honor, that the Massachusetts beneficiary would then owe taxes on the money that they had received, assuming that they hadn't already been taxed, but that's my understanding.
But they being taxed, you mean assuming their trust had not been taxed?
Correct. I think, assuming the income had not already previously been taxed, yes, I believe.
But in that scenario, if the trust also has some portion for unascertained and unborn beneficiaries, they would not be taxed. No tax would apply because it's not going to be paid out to a non-existent person.
Assuming that there is no Massachusetts inhabitant trustee, yes, there would be no tax.
And they're all paid the same rate of tax of 5%, or whatever the rate of tax is for non-wage income.
I believe so, Your Honor, but I'd have to go back and look very carefully at the statutes to know if that's true or not.
So there might be, I mean, presumably depending on the types of investments, the way the income was earned, capital gains, some.
Possibly, Your Honor, yeah. But
We're already out of my depth.
All right, thank you.
thank you, Your Honors.